Hello and welcome to this FedSoc Forum webinar call. Today, September 23rd, 2025, we are delighted to host this discussion entitled Religious Arbitration, Family Law, and Constitutional Limits in Texas. My name is Matthew Sawtell, and I'm Assistant Director of Practice Groups at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's call, as the Federalist Society takes no position on particular legal or public policy issues. In the interest of time, we'll keep the introductions brief, but if you would like to know more about our panelists, you can see their full bios at fedsoc.org. Today, we are fortunate to have as our speakers Dr. Kanta Ahmed and Professor Eugene Volokh, and we are pleased to have Karen Lugo as our moderator. Ms. Lugo is the founder of the Libertas West project. One last note, throughout the panel, if you have any questions, please submit them through the question and answer feature in Zoom, so that we will have access to them when we get to that portion of the webinar. We do ask that questions submitted there both pertain to this discussion and end with a question mark. With that, thank you for being with us today. Karen, the floor is yours.
Thank you, Matthew. Thank you to the Federalist Society for hosting today, and appreciation for the work that all the volunteer practice group members do that organize webinars like this one. Many thanks to Dr. Kanta Ahmed, and please see her very accomplished bio in the link for this webinar. Also, thank you to Professor Eugene Volokh. His always topical legal blog is great for both lawyers and non-lawyers alike. In addition to moderating today, I will lay some foundation as I've observed, commented on, and consulted in some of the related pivotal developments in areas around the world as well as the United States. Current news accounts reveal that a no Sharia ban has been introduced in Congress. If enacted, the legislation is described as, quote, barring courts from enforcing any judgment, decree, or arbitration decision based on Sharia law or any foreign system that violates constitutional rights. Governor Abbott signed similar Texas legislation in 2017. Approximately 15 states have passed a version of the statute called American Law for American Courts, or ALAC. Of course, this rejection of foreign law where it violates American standards of due process and other civil rights protections already exists in comity tests. Over the last 20 years, I have tracked Islamist activity that would potentially trigger the protections of ALAC. I have spoken at city, county, and state hearings to warn of results, much like Britain and European locations, if accommodations and permitting are not structured reasonably and equitably to constrain activity while providing enforcement mechanisms. Transparency is also critical as a component when there is a history of rejecting American foundational values and legal norms. I testified before the Texas legislature over several sessions on the policy reasons for reinforcing state-level imperatives of American constitutional standards. However, my experience with developments in Minnesota between the city of Bloomington and Dar al-Farouk Mosque revealed practices that have been repeated to some degree in other communities. Whether city officials are overawed by applicants wanting to permit a citing of a mosque, or whether officials are simply eager to prove inclusive intent, they often vote to locate mosques in residential neighborhoods with only basic limitations. This despite contemporary indicators of heavy activity and attendance on websites or evident at current locations. These vague limitations are complained of being dissimilar to treatment of applications submitted by other religious institutions. When much of familial, social, and educational life is centered in the mosque, traffic and activity levels may be surprising, and they provide for unusual strain on surrounding residential use. Conflicts are inevitable unless careful structure is implemented. In part, the local government approach may be understood in light of some Muslim applicants' early threats to sue under RLUIPA, the Religious Land Use Statute, and of past Justice Department investigations that resulted in onerous discovery, discrimination training at settlement, signage at City Hall, and periodic data transfers for federal government analysis. At the Dar al Farouk location, years of reported overuse, control of city park space and fields, permit, code, and traffic violations left some residents exhausted, and over years, homes were sold to mosque congregants. One woman who resided near the mosque described the developments over years in her illustrated blog posts. Mosque leaders and city officials grew exasperated and eventually charged her with criminal harassment. This was triggered by posts illustrating charter school recess monopolization of a city playground that included images of children. Robert Muse of American Freedom Law Center argued her case to the Eighth Circuit Court of Appeals and won vindication of her right to speak on this matter of public concern under the First Amendment. As detailed in my book, despite our LUPA considerations, a fledgling Christian Nigerian church was treated much more strictly in a subsequent permit application procedure by the same city. That permit was denied. While not established as exclusively Muslim, communities may still develop this separatist character. Many become closed, opaque, and leadership only interacts with the surrounding community and culture on specified terms. Communities and states have turned to legislation like ALAC as insurance, but ALAC did not help when a Texas Sharia Muslim marriage ended in divorce. The wife filed her divorce case in civil court, although the 2008 marriage was officiated by imams in a North Dallas Muslim, quote, arbitration center. The fact that the IAD prenup and marriage certificate, both dated the same day, reveal a Sharia marriage performed in the Dallas area was a stunning revelation. In the event of a dissolution, the document states, quote, the law of the land will not be applied at all, end quote. The handwritten number 677 on the prenup may indicate the preceding number of ceremonies officiated at that arbitration center. The terms on the face of this marriage agreement, as quoted by the Texas Supreme Court, included the couple's, quote, belief that Islam is binding on them in all spheres of life. The agreement provides that, quote, any conflict which may arise between the husband and the wife will be resolved according to the Quran, Sunnah, and Islamic law in a Muslim court or, in its absence, by a fiqh panel, end quote. The agreement then explains how the members of a three-person panel will be selected and provides that the panel, quote, will not represent the parties in conflict, but rather serve as impartial arbitrators and judges guided by Islamic law and its principles. According to the agreement, the majority decision of the fiqh panel will be binding and final. Professor Volok will discuss the legal and procedural aspects of this case, but the enormous expense of the wife's effort to move the divorce out of the tribunal through 4 courts over 2.5 years had to have been daunting. Valiant American Muslims provided invaluable insight at 2 hearing junctures. Dr. Zuhdi Jasser on June 21st submitted an affidavit to complete testimony that he was not allowed to bring in the trial court. And he said the Islamic prenuptial agreement is unconscionable and against public policy. The Islamic tribunal will not enforce civil rights, U.S. constitutional law, or American law over the provision of Sharia law. The Islamic tribunal will apply Sharia law and will discount the testimony of the wife and thus deny her equal protection under the law. The prenuptial agreement will not provide for a fair distribution of the marital assets to the wife in the divorce, will deny her a no-fault divorce, and may deny her custody of her son under the application of Sharia law. Ayaan Ali, in her book Heretic, says, where Western laws generally set boundaries for what cannot be done, leaving everything else permissible, with Sharia the system is reversed. The list of things that can be done is very small, while the list of what cannot be done overwhelms everything else, except for the list of punishments, which is even longer. Ayaan quotes Ernest Gellner saying, In traditional Islam, no distinction is made between lawyer and canon lawyer, and the roles of theologian and lawyer are conflated. Expertise on proper social arrangements and on matters pertaining to God are one in the same thing. The Arbitration Center has been questioned over time. The website mission statement once spoke of the preeminence of Islamic law, but now exhibits conflicting statements, first saying that the quote objective is to follow state and federal law. But Article 3 says that the Islamic tribunal shall apply the principles of Islamic jurisprudence or fiqh. And Article 7 says that the judges of IT, and judges are in quotations here, must have a degree in Islamic law approved by a renowned Islamic institution. There are now similar centers in other states. While the tribunal's announced mission is now to deliver non-binding arbitration, this marital agreement was expressly binding. It is very rare for a Muslim Sharia divorce to be presented to American civil courts. First, the terms are not subject to resolution in the equitable fashion that state law requires. And second, Muslims have reported that the wife often faces tremendous family and mosque pressure to keep the dispute within the Islamic system. American constitutionally minded Muslims provided this kind of invaluable insights at the Texas Supreme Court level as they submitted amicus statements. Again, Dr. Zuhdi Jasser, here's a short summation of his very long, detailed, thorough letter. He said, if these systems are founded upon documents and agreements that are opaque, deceptively executed, and riddled with coercion, they erode the integrity of the entire precept of religious freedom upon which they are supposedly based. And Rahil Raza, who worked for years in Canada to evaluate and expose coercion in Muslim arbitration systems, stated, quote, Muslim women, like all other American citizens, need the protections offered by the American constitutional court system, which too often pushes them away and forces them to fend for themselves with no defense from the constraints of a foreign system contained right here within the nation that was supposed to be their home. Of note, due to the results of this investigation that Rahil Raza participated in, Canada banned all religious arbitration options for marital matters since 2005. Azra Namani and Soraya Dean also submitted briefs as practicing Muslims who urged the primacy of American constitutional due process protections. This case may have finally been resolved according to correct constitutional standards, but the fundamental challenge remains. Much that relates to life, politics, family, and law occurs in the mosque, Islamic school, or a tribunal, and for the most part, it stays there. Upon reports of a Muslim-exclusive city called Epic, planned for north of Dallas, Governor Abbott signed a law. It, quote, banned Sharia compounds in Texas. However, some are concerned that the same secrecy stonewall will prevail. The new law would require disclosure if the purchase is an interest in an entity and not of real property. The law would prohibit discrimination in the acquisition of or transfer of property or entity interest, and the law requires that dispute resolution not to be expressly limited to adjudication in a tribunal. The question remains, as in all these scenarios, how to query, inspect, and enforce when communities are capsules that include independent education systems, societal structures, and dispute resolution centers. Victor Davis Hanson, in his book, The Dying Citizen, demonstrates that tribalism and individualism are in absolute tension. Beyond tribalism, European and British examples confirm what we have seen in parts of Michigan, Minnesota, and elsewhere. Islamism may act as a screen around settlements and then drive them to become politically and culturally hegemonic. Many Americans are also aware of very recent news items that feature a mayor in Dearborn admonishing a citizen who complained of street naming in honor of a purported Hamas sympathizer. The mayor told the citizen during the city session that he was, quote, not welcome here, and that the mayor would throw a parade when the citizen departed. A proposed police patch has been introduced with Arabic lettering in the nearby city of Dearborn Heights. It was later withdrawn. And an imam has been recorded patrolling areas near Houston, declaring by megaphone that Muslim proprietors should not sell alcohol, lottery tickets, and tobacco. But America has the singular advantage of brave, articulate, steadfast Muslim activists who value constitutional ideas. These courageous and enlightened Muslims are asking two questions of American lawmakers and citizens. Will a way be found for Americans to protect religious Muslim exercise and expression, yet deny the authoritarian control and coercion of extremists? When will American policy and religious leaders finally recognize the value in consultation with proven enlightened Muslim reformers and thinkers? In conclusion, Ayaan Hirsi Ali also writes in Heretic, Why Islam Needs a Reformation Now, and I quote, in the Cold War, the West celebrated dissidents such as Alexander Solzhenitsyn, Andrei Sakharov, and Václav Havel, who had the courage to challenge the Soviet system from within. Today, there are many dissidents who challenge Islam, former Muslims and reformers, but the West either ignores them or dismisses them as not representative. This is a grave mistake. Reformers such as Tawfiq Hamid, Zuhdi Jasser, Azra Nomani, and many others must be supported and protected. They should be as well known as Solzhenitsyn, Sakharov, and Havel were in the 1980s, and as well known as Locke and Voltaire were in their day, when the West needed free thinkers of its own. And so next, one such Muslim commentator is here to speak for us, and it is my distinct honor to introduce Dr. Kanta Ahmed.
Thank you so much, Karen. That's quite a huge set of facts to follow. And there are a number of things that come immediately to mind. And there is a connection between the Muslim woman in Texas who was asked to sign a prenuptial agreement which clearly denied her of her constitutional American rights, and the connection between the construction of a mosque that threatened and eventually dominated an area. What we're seeing is the efforts of Islamism, and I use that very specifically, to dominate the public space and dominate the individual. This is not about a conflict with Islam itself. And we're using some words that are often described or wielded in the press, which have very specific meaning. Number one, Sharia as a word appears only once in the Quran in one verse. And that is important to notice. It only refers Sharia to the way, meaning a moral code, a path of doing good. It does not specify a body of law. After the Quran came a huge effort by jurists, all of which is post-Quranic thought. And that is loosely known as Sharia and has four schools of thought and various, as you're describing, jurists and various bodies of case law that you as scholars and your audience as legal scholars will be more familiar with than someone like me that practices Islam and practices medicine, but comes across all of these conundrums. In the United States, I'm astounded to discover what has happened to this one Muslim woman who probably represents many other Muslim women, because it echoes very much what I have seen in Britain, what is reported also in Belgium and France and the Netherlands, which has been deeply researched by Islamic scholars of the same thinking as you're describing, my colleagues Zuhdi and Asra. Elham Manea, a very important Swiss, Egyptian, Yemeni scholar of Islamism and how it isolates and subjugates women. Islam itself gives the individual freedom to choose their partner and specifically gives the woman the freedom to divorce. In fact, any assets accumulated in the marriage during any assets that enter into the marriage belonging to the woman will always remain hers and indivisible at the end of the marriage. And she has the choice, if she wishes to, divide them. The concept that she would not be allowed to divorce and be denied the privileges here in the United States is astounding, coming from a place like Texas. And I was completely unaware of this. You brought this to my attention after I learned about the Epic City development in Texas and wrote about that in Newsweek and spoke about that with Will Kane at length. And it tells me that the project of Islamism is well underway here in the United States, and it is a war for the secular place. This is about Islamism's effort to desecularize the public space. I absolutely agree that we have freedom of religion in the United States. It's one of its extraordinary strengths that was put into place by the framers. But freedom of religion sometimes has manifestations which limit freedom. Freedom of religion and freedom of belief are sacrosanct. But the manifestations of that, which are going to confine and restrict any individual in America in any way, are not welcome. And that is what we're seeing here. So without question, US constitutional law has to act above these efforts of what are an invented Sharia, what are a legal fiction. They are being presented as a religious right to a trusting and naive and well-educated but not informed American legal body that is not familiar with Islamism. Let me come to Islamism. Islamism is a 20th century political totalitarian imposter posing as the religion of Islam. It was founded in 1928's Egypt. It believes in the manifestation of Islam only through statehood. It is consumed with forming caliphates. That is not how the history of Islam shows us, where there was generally a Muslim ruler that ruled over a state. That entity is known as siyasa or statecraft, and there would be a separate leader that would adjudicate religious law, never overturning the rule of the kingdom, so to speak. That's a very simplistic way of describing it. There was generally separation between state and Sharia. Sharia itself in the Quran, mentioned only once, generally focuses on civic law and some penal code. And that has been modified in many ways. With the rise of Islamism, which we can say the mothership of which is the Muslim Brotherhood, we have also seen the way that Muslim states, beginning, let's say, with Saudi Arabia, where I lived 25 years ago, under a Wahhabi manifestation of Sharia law, which rendered me a legal minor as an adult woman, even though I was providing high-level medical care. Those states utilized Islamist versions to impose Sharia on the individual, whether they were Muslim, whether they were non-Muslim, whether they were a pluralist Muslim or of a minority sect, or irrespective of their identity. It did not provide freedom of expression or freedom of worship. Now, the very epicenter, the engines for promoting that ideology, Saudi Arabia was chief among them, but also the surrounding Gulf states have themselves repudiated Islamism very emphatically. So Muslim Brotherhood ideology is outlawed in Egypt. The Egyptian public during the Arab Spring came out to the strength of 93 million individuals overturning Mohammed Morsi, who was a Muslim Brotherhood president of Egypt. So millions of Sunni Muslims have overturned the Muslim Brotherhood when it attempts to govern over Muslims. The Saudi Arabians have outlawed it. The United Arab Emirates has outlawed it. And they even had a boycott with Qatar because of disagreements over the Muslim Brotherhood. What we're seeing now, and it's quite clear, is this rejection of Islamism in the epicenter of Islam itself is driving and has animated Islamism in the Western world, Western Europe, and now here in the United States. And what I'm saying is I am a Muslim who practices Islam. I've visited the Mecca on pilgrimage. I pray, I give my charity. I mean, I have absolutely a good connection with my faith. I'm not an ex-Muslim. I'm not a former Muslim. I'm practicing Islam. But what I see happening is a manifestation claiming identity as a religion when it is actually a political ideology. I was deeply concerned to see the proposal for a building project in Texas, Epic City, because it seemed to me on the facts that I was provided, essentially exclusionary of Americans that were not of a Muslim identity, more concerning that it was capturing generations of Muslim from cradle to the end of the life, which is particularly focused on educating children, boys and girls at the earliest stage, and then keeping them siloed from the mainstream community. And that kind of capture, we best describe in the words of academic Elham Manea as a closed society. That's what you're describing, where a mosque in a residential area begins to encroach on the local housing until a neighbor feels that there's no place for her, as you're describing in that case where a woman was accused of some kind of harassment or other violation. So closed societies are fundamentally dangerous. Closed societies are an absolute aim of the Muslim Brotherhood Project, the Islamist project, and closed societies thrive in a secular, pluralistic, liberal democracy, which is very forgiving to people from diverse backgrounds, whether they are ethnically or racially or diverse in any other way. But that is strengthening this kind of fabric, which undermines our social cohesion. So if I am to give any kind of helpful advice, is when you're contemplating these dilemmas, you have to ask yourself, is there an intention to impinge on the public space? And the answer often will be yes. Is there an intention to undermine social cohesion? Whether it's an intention or it is not an intention, it will probably be a measurable outcome. Is that in violation to our spirit of being American, as well as the limits of our constitutional law? Why should we be concerned about this? Why is there an effort now in Congress for a no Sharia proposal? When you say no Sharia ban, I assume the congressional leaders are proposing we don't want Sharia law in the United States. It is because they can sense that there is a threat to the general liberal pluralistic milieu. I think also the other salient part in your story is the fact that it got your attention that a woman was mandated or somehow misled into signing a document that ultimately undermined her constitutional rights. Women are the first targets, girls and women. So what we're seeing now in Europe, in Britain, for many years, in Europe, is a demand for specific schools to educate Muslim children, whether they are learning the general curriculum or whether they want religious education as well. This results in a focused ghettoization of a particular cultural group that is now being provided some secular education from the authorities and religious education, which is generally provided by Islamist groups, Muslim Brotherhood acolytes, or Islamist organizations. And so we see in Britain very little girls. I'd be very interested in the story of this woman who brought and finally achieved the divorce. What is the story of the little girls in her community? is there veiling being mandated, including prepubescent veiling, which we're often seeing in Britain, little girls age 4, 5, 6, 7 being veiled as if they're adult women. The veil itself is a whole nother discussion that we can have. And once these women are captured, they're generally subjected to a patriarchal sense of not only how they should dress, but also how they should behave, where they should move, what they should study. And it is associated with early marriages, compelled marriages, or marriages that must be within the community. And sometimes in Europe, we're seeing a very large percentage of the women having arranged marriages are arranged to marry individuals often from Southeast Asia, migrating to Britain or migrating to Europe in order to enter those families. So speaking about this might make many people deeply uncomfortable. And even in the United States, I face often calls of being Islamophobic, as does Zudi or as does Asra or Sharia. And that's been leveled to me in person and also in print. But this is not something that is Islamophobic. And if we can just dispense with that term, Islamophobia serves only as a political and judicial shield to the Islamist or the Islamist project. It does not shield a pluralistic Muslim, whether or not I wear a veil, in my day-to-day activities. The United States still guarantees and protects Muslim individuals from hate crimes and anti-Muslim xenophobia. That is completely separate. But to level this kind of scrutiny at individuals that were preparing that prenuptial agreement, or the presence and permitting of a mosque in a residential area that led to essentially the domination of the public space and no room left for anybody that wasn't a mosque goer or wasn't integrated into that community. That's an exclusion of an American from a public space. That kind of scrutiny is essential. Now, maybe the most, and I'll keep my remarks brief, but maybe the most important example that you could consider is what has recently been declassified by the French government in terms of how the Muslim Brotherhood operates in France. And that was the most comprehensive report of the work of the Muslim Brotherhood in a Western democracy. It was a report that was published eventually in the Le Figaro because France felt it was so important people had to know, and it's over 100 pages. It shows that the Muslim Brotherhood is operating through schools, through local councils, through school boards, through over 280 NGOs, networks of mosques numbering over 100, schools to teach the Quran with tens of thousands of students, I think 66,000 students studying the Quran in France, 1/3 of which were Muslim Brotherhood associated, and 21,000 students in some form of an Islamic school, all of which was tolerated and allowed by the French government. And what that leads is to an incredible intellectual ghettoization, as well as a community ghettoization, separate from any economic or demographic or employment or migrant hardships that might also fragment society. And most importantly, they revealed the Muslim Brotherhood is operating less like a religion and more like a secret society, because there were 1,000 designated Muslim Brotherhood leaders that would meet clandestinely, and they then interact with their communities, with local politicians that are beholden to an electorate that is now heavily penetrated by the Muslim Brotherhood. This is how, by engaging in local politics, that an issue that seems social, the divorce of a woman who was married to a Muslim man, now is actually part and parcel of a major effort to promote the identity of Muslims in America to be in line with the Islamist project. And that is ultimately denying a Muslim woman her right to divorce, which Islam does grant to a woman, not only a Muslim man. one observation that's come from the research of Elhan Manea into exactly these problems. And there's a marvelous book which talks about the perils of nonviolent Islamism. Every lawyer interested must read that treatise. Is that many of these populations where this is happening are coming from Pakistan, country of my family's origin, and Bangladesh. And this seems to be very common in Southeast Asian communities, and it is something that is desired. And so if I can maybe just close, I want you to understand Islamism, however much it wants to be branded as such, Islamism is not Islam. Why does it seek to be branded as Islam? Because saying it is Islam grants it religious freedoms and protections, particularly guaranteed by the United States. Number two, if Islamists are claiming a religious practice is privileged or should be accommodated in the public space, I think that has to be questioned, even as I believe in the right for all religions in the United States to have a place of worship, to be able to invite somebody into their faith, to be able to observe whatever rituals. But when it begins to encroach on the public space and it begins to drive desecularization, that then threatens our fabric for all Americans, including pluralist Muslims. And finally, if you are going to enter into any of these discussions inside or outside of a courtroom, be prepared to be tarred with the charge of Islamophobia, which has a huge machinery behind it. Even as I said, that the Gulf countries, Saudi Arabia in particular, where I've been invited and honored for my efforts to combat Islamist extremism by the Saudis, they are also proposing to normalize into international law the concept of Islamophobia, because they are seeking to create structures where international law, which is generally Western and secular, is going to be put up against an Islamist version of an alternative. And so this is tremendously charged, and I could see how you described this woman going through tribunals at several levels of courts. She did not encounter a judge who could see beyond that. And whether that was lack of information or intimidation or sympathy with Islamist viewpoint, we very much need to work with jurists so that they can expose Islamism for what it is. There is some very important scholarship on this, which I often refer to in my writings in the form of the work of Bassam Tibi, who is a Damascene origin German scholar on Islamism. But it is work that comes at a high price, and also, unfortunately, in our media environment in which I'm engaging frequently, additionally becomes a further lightning rod, which then can trigger real anti-Muslim xenophobia. But Islamism, it's being presented as the solution for Muslims, particularly in the West. It is not a solution, it is actually the source of the crisis. And I'll stop here.
Professor Volok, we would welcome some remarks on how this case did proceed and what the final resolution was.
Oh yeah, thanks. I'm going to save the details of the case because I think we're talking about here something much broader. And we've heard a lot about Islam and Islamism and what should count as true Islam and such. I wanted to talk about American law and American history. So one of America's most prominent contributions to human rights is religious freedom. It wasn't invented by the U.S. I mean, the Dutch were pretty decent on it back in the day, but it was a major element of American equality and American freedom that we've tried to maintain throughout American history. And that has included, of course, freedom for all sorts of religious groups, both religious groups that were trying to be integrationists that tried to work within society, and those groups that were very much self-ghettoizing. The Amish, to give an example. The Puritans back in the day were also self-ghettoizing too. They didn't respect religious freedom perhaps as much as we would have liked, but certainly many other groups were this way. Today, of course, we see it in plenty of other communities. Orthodox Jews are a classic example. So American religious freedom being about freedom, being about something that operates even as to groups that are not like our groups, has long protected groups that are somewhat isolationist. It has long protected, to give an example, of course, all familiar to all of us, groups that want to start religious schools in part precisely to make sure that their children are educated in a particular religious community. Again, some of those are relatively, at least like modern Catholic schools, are relatively aimed at integrating people into broader American life. Some ultra-Orthodox Jewish schools are not. Yet they're of course protected by religious freedom. What about groups that have political ambitions? Well, we're well acquainted with one of them, and that was the Catholic Church. Of course, that was one of the major advances in American religious freedom law over English law, is that England viewed Catholicism as a dangerous and in some respects not quite outright outlawed, but certainly very discriminated against religion, because it was seen as part of a foreign religious movement that had political ambitions, that did not itself respect religious freedom. And it's true, Catholicism of that era did not respect religious freedom. It had as its leader actually someone who was in fact a political ruler. The Pope ruled the Papal States. And of course, it also had other religious figures, most prominently Frenchmen, the worst kind, but also Spaniards, who were throughout much of the history of, let's say, the 1600s and 1500s and 1700s in England, were foreign countries that were overtly Catholic. Yet, by and large, American law respected Catholic religious freedom, allowed Catholics to have religious schools, allowed them to have religious accommodations such as sanctity of the confessional, which is something that emerged into American law largely through Catholic groups. There was some hostility, and perhaps some justifiable hostility, against Catholicism, people saying Catholicism is bad in various ways. And it may be that many strands in Catholicism, especially in the 1800s, before the modern, I think, much more pro-religious freedom Catholic Church, were dangerous in many ways, but American law protected them. To give another example of what American law protected, is American law has long made it possible for religious groups to live together in religious communities. And generally speaking, my sense is, there are a lot of these religious communities, people don't really want to move in there. If you're not Amish, you probably don't want to live within an Amish community. If you're not an Orthodox Jew or ultra-Orthodox, let's say, you probably don't want to live in a community that is highly ultra-Orthodox. Sometimes people would not have just tried to buy houses there. Sometimes people would not have been allowed to buy houses there because the community sort of pressured people not to sell to them. That's an interesting question, whether that's consistent with fair housing law. Interestingly, this Texas law that aimed to limit this Muslim community actually was a limitation on pre-existing Texas law, which actually allowed religious organizations, associations, and societies to have religiously exclusive communities. Again, I think that's been a long-standing part of American religious freedom. Another part of American religious freedom is that we have not decided what true Catholicism is, or what true Judaism is, or what true Islam is, or even what true, well, maybe perhaps especially what true Protestantism is, right? So it may very well be that Islamism isn't true Islam in the sense that real Muslims ought to believe. That is no concern of American law. American judges are precluded by the First Amendment from making such judgments. If there are some people who believe in one understanding of Islam, They're protected by religious freedom. There are others who believe in other understanding. They're protected by religious freedom. If they want to organize some of their religious bodies in a relatively secret way, nothing says religious freedom is limited to people who are willing, I don't know, to put themselves on some list of official religious leaders. American law doesn't keep such lists. Likewise, if they have a political agenda, or if they want to desecularize society. We certainly know many groups in America, predominantly Christian groups, who would like to desecularize society. They're free to do that. Now, there are certain things they cannot do consistent with secular law, but they can certainly advocate for it. Nobody will shut down a Christian church or a Christian school on the theory that, well, they're trying to aim to desecularize society, because how secular society should be is itself a proper subject for religious and political debate. To give another example, arbitration. Religious arbitration has long been practiced in America. My understanding, it had chiefly been practiced in two contexts. One, which was for Christian churches when they were debating things having to do with church property. In fact, American law basically sharply limits the ability of secular courts to resolve disputes among religious groups or within religious groups over who's the real authority within this church, let's say, who really gets to run this or own this particular piece of property. It can only be done through neutral principles of law. And sometimes there may be deeds that say, I donate all this money to this church only so long as it remains Orthodox. Not Orthodox with a capital O, but a lowercase o. Well, that's not something that a secular court can conclude. In fact, it was in the 1870s that the Supreme Court first made clear that it's not something that a secular court could conclude. What is seen as the proper way of dealing with that? Well, you defer to the religious arbitrations within the religious body. So some bodies may have a chief synod or some other kind of religious court that decides which particular, let's say, rival claimant to the property of some particular congregational church gets to prevail. So that's one form of arbitration that's been longstanding. The other, of course, is Jewish arbitration. Orthodox Jews are generally speaking discouraged. I oversimplify here, famous line, 3 Jews, 4 opinions. So I would hesitate to say, I'm not really that Jewish. I'm irreligious myself, but certainly as an ethnic Jew, I feel the same way. So I hesitate to say something about what Jews believe. But what many Orthodox Jews believe is that it is not proper to bring religious disputes in front of secular courts. So religious disputes are routinely resolved through not even religious disputes within the Orthodox Jewish community, could be commercial disputes, are resolved through religious courts, which each one of them is called a Beit Din. And it's, as I understand, it usually has 3 rabbis on it, and they pass judgment on this. Some of this may be binding arbitration, which is then contractually, as a matter of secular law, contractually binding on the parties. But even in the absence of that, of course, within a tightly knit community, there's going to be a lot of pressure for religious Jews to adhere to that. And under American religious freedom law, Muslims are just as entitled to have this kind of arbitral bodies as Jews are. What about family law? Well, in fact, my understanding is that family law in very many religious communities is very much, or things having to do with marriage and divorce are very much something that is considered through the lens of the religious group. And in particular, among Jews, women, in order to remarry after they get divorced, need a so-called get, which is a religious divorce. Most American courts that have considered this have said that a secular court cannot order the giving of a get. So if a woman wants to be free to, under a religious law, to remarry, she has to go to a religious tribunal to get this get. And then the religious tribunal will often order the husband to produce the get. And there's a lot of tension as a result. But generally speaking, unless one is willing to say you can't have a Jewish arbitration, you can't have Christian arbitration, you can't have secular arbitration, unless one's willing to completely reject arbitration, well, then I think Muslims are entitled to arbitration as well. So it's American law. It's not like just religious law or foreign law. It is American law that religious freedom is protected. It is American law that groups are entitled to be in America and to try to be insular or not insular, to try to be secularizing or desecularizing, to have their own conventions and their own practices and often their own communities. Now, of course, there are limitations on that, and rightly so. The important factor is the limitations can't say we're going to single out some religious group because we think that they're dangerous. We think they have political ambitions. We think they are unfair to the women in their midst or whatever else, by the way, a charge that has been levied at very many religious groups, including Christians and Jews, often correctly, including Catholics, often correctly. Rather, there are, generally speaking, secular standards of behavior that potentially are applicable to a wide range of people, including religious behavior. So just to give an example, indeed, if a state wants to completely ban religious discrimination in housing, it could do that probably. That would be a secular standard. It's an interesting question whether there might be a free exercise clause exemption, maybe not. It's just that many states, as a matter of just religious freedom principles, try to accommodate groups, not particular groups, but any group that wants to have religious communities. To take another example, family law is considerably regulated. So many states, for example, provide that a spouse gets is entitled to a particular share of a property settlement and may not waive that through contract, except through certain means, certain kinds of prenuptial agreements. If indeed a state were to say that divorces cannot be arbitrated or a property cannot be arbitrated in a divorce, then that could apply equally to Muslims. Again, it would have to apply to Jews and to others as well. To give another example, my understanding is that most states do not allow arbitration of child custody disputes. And that is in part because arbitration is a matter of contract. The parties can enter into a contract, but a child cannot. So to the extent that the child custody dispute adjudicates the interests of the child, it may be something that, again, can't be arbitrated not just by Muslims, but by Jews or by anybody else. You can't have even a completely secular arbitral provision. Likewise, in the Inter Ayad case, there was a provision having to do with prenuptial agreements and arbitration. State law provided that certain prenuptial agreements had to follow certain state law rules. And the Texas Supreme Court said that those rules needed to be followed and hadn't been properly followed below. So I think that's fine. But again, note, none of these rules say, oh, we find this religious group to be especially suspicious because they're insular, or we find this religious group to be particularly bad because they have some kind of political ambitions. The rules have to apply equally to all religious groups, regardless of whether they think they're ultimately a force for good or ill in the world. Because, of course, the most natural thing is to assume your religion is a force for good and other religions are a force for evil. Sometimes you may even be right, but that cannot be under American religious freedom principles a position that American law follows. So this is a big picture view. We've run a long time, I think the three of us. I see there may be 6 minutes left, if I'm right, that this is an hour long. So I want to make sure there's time for questions. But I just wanted to lay this out. There's a long-standing, I think, very worthy tradition of American religious freedom law. It's protected Catholics when they were viewed askance. It's protected Jews when they were viewed askance. It protects religions, even recognizing that sometimes religions are not fair to members of the religious group, often to women members of the religious group. But as a general matter, it does not say, oh, this isn't real Judaism or real Catholicism or real Islam, and therefore it is unprotected. So I want to close with that and see, we'll have, I hope, some time for questions.
Mm-hmm.
Matthew, do you have any audience questions?
Yes, I do. This is one from John Scheller. He asks, wouldn't the Federal Arbitration Act preempt all state law purporting to ban religious arbitration?
Professor Volokh.
So I'm not an expert on specifically the Federal Arbitration Act. I do know that there are that there are certain kinds of arbitral agreements that might be voided as contrary to public policy. And for example, if, for instance, by the way, this is an argument that has sometimes been made with regard to Muslim arbitration, if there's evidence of discrimination based on race or sex by the arbitrators, my understanding is that that might indeed be precluded. I do think, as a general matter, arbitration is something that has long been favored in the American legal system, chiefly because it's a way of resolving disputes, ordinary commercial secular disputes, more quickly and less expensively. But again, under American religious freedom principles, if you're entitled to do something for religious purposes, for secular purposes, you're entitled to do the same thing for religious purposes.
I would add that when we reach a point where the conflict of laws, the arbitration system is in such deep conflict with American constitutional protections that the religious shroud around what would be religious arbitration is compromised, because the entire, in this case, the coercion behind the agreement, we are not sure of. We don't know. We hear commentators discuss what likely happened, but what we do know is that the face of this agreement, and there were several other entries regarding the child shall be raised as a Muslim, any custody agreement would be resolved under fee. All of these issues that we look at as requiring a degree of impartiality, and certainly if two parties have agreed and gone into an arrangement like this as what we might say consenting adults, but a woman who has passed a piece of paper, who expects that this is part of state marriage documents, is what her testimony was. She signs this and then later finds out that she gets $32 among all of these other issues that are to be decided by this panel of three, quote, arbitrators, judges, who are not even cognizant. We don't even know if they are trained in what her rights and protections should be. Granted, it is possible to enter an arbitration agreement and surrender to that. But in these cases, that's the big question. What did the woman understand she was giving up? What did she understand her status would be at the point that there may be a reason to challenge the entire arrangement?
So I just want to highlight there are two separate things going on here. One is a question of whether there was adequate notice, let's say. And by the way, that's an issue that sometimes comes up with secular arbitration too. Oh, we didn't know that there would be an arbitration provision. Sometimes that could be a basis for setting it aside. And again, that's just a standard secular principle that would be applicable regardless of the religious nature of the arbitration. But the other thing is about supposed conflict with American constitutional norms. So here's an American constitutional norm: right to civil jury trial. It's right there in the Seventh Amendment. It's present in basically every American constitution. But of course, arbitration waives that right. People are entitled to do that. Another norm is that indeed judges are not chosen based on religion. But again, for a century at least, but probably more, many American Orthodox Jews have resolved their disputes by turning them over to Beit Dins, where the people are chosen because they're Jewish, because they're rabbis, and they apply religious law. So generally speaking, people are entitled by contract to provide for the application of law that is religious, to provide for application of law in a way that does not go along with all of the American constitutional rules. So again, one might say that there could be, for example, principles limiting arbitration, for example, prohibiting sex discrimination in evaluating the testimony of witnesses and such, which, again, this could be secular principles that could be insisted on for all religious tribunals. But I don't think we just categorically condemn arbitration simply or whenever it's inconsistent with kind of the way that American courts operate, precisely because under American law, under the Federal Arbitration Act, American law provides that people can indeed get out of a system which has a particular kind of procedural rules and go to a system that has different procedural rules.
Matthew, if I could just conclude, I don't think we ever reached, there may be some suspense, the conclusion of how this case was resolved. But the Supreme Court in Texas did rule that the lower courts abused discretion. They stayed the ruling that the woman was to go back to the tribunal, and they did grant her the civil hearing. And so saying that on the face of the arbitration agreement, there should have been analysis for whether it was valid and enforceable under U.S. constitutional law.
Could I say something, Karen, please? May I?
I know we're at our time stop, Matthew.
I think you can give the last comments, Dr.
Thank you.
Abbott.
It's very fascinating to listen to my colleagues, particularly Professor Volokh, and everything that he says is authoritative and obviously absolutely true. That is exactly the vulnerability of the United States. And we keep coming back to the fact that this Muslim woman was adjudicated on by her own religious leaders on the basis that they're operating in some kind of Islamic legal process. The nature of the Islamic rulings that are being propagated in this instance and many others are an Islamist Sharia-fication, if you want to call it that, of laws in Muslim societies. And so these women are completely captive to an Islamist version of their reality. And while all Islamists are Muslim, most Muslims are not Islamist. The Islamist project is absolutely committed to forming Islam through a concept of statehood. And that means replacing our democratic surroundings with what they see as a caliphate. They're animated by a virulent, lethal, cosmic enmity with Jewry. They're obsessed with purity and authenticity. And that's not my opinion. That is a body of scholarship for decades that exposes Islamists masquerading as a religion. And because we are so well protected for religious freedoms, the Islamist project is exploiting that space in the United States and imperiling Muslims, Muslim women and girls in particular, but Muslim men also. And unlike the Amish or the Orthodox Jewish person or the Catholic or the Protestant or any other religious group, we have a unique problem with non-violent Islamism that converts to violent evolutionary Islamist jihadism. That doesn't mean that a woman who was not arbitrated on for the end of a marriage fairly is on some kind of pathway or in even in a community that's on a pathway to violence. But this kind of intolerance is growing. It's here in enclaves. It's gaining strength, and it gains legitimacy and currency because of the protections afforded to all people of faith. And that itself is the hazard to our secular liberal democracy that protects all of us, irrespective of what we believe. And so it does present a conundrum. It is different than other ideologies that don't have this enormous machinery behind them that is driving, for instance, post-October 7th, some of the most virulent and lethal Islamist anti-Semitism that we've seen in almost living memory. So I'm very concerned that the American law, as exquisite as it is privileging this group at the expense of a pluralist, heterodox Muslim woman like myself. Very few Muslim women have the privileges, even in the United States, that I might enjoy. And a lot of it is because they are confined to their own patriarchs in their own community and society. Thank you.
Well, thank you all. This was a great conversation. I wish we could talk longer and get to more of the questions, but I want to respect your time. So on behalf of the Federalist Society, I want to thank our experts for your valuable time and expertise today. I want to thank our audience for joining and participating. We also welcome
Yes.
listener feedback via email at fedsocforums@fedsoc.org. And as always, keep an eye on our website for more upcoming virtual events. Thank you all for joining us today. We are adjourned.